And the same thing goes in Hale versus Henkel, which clearly states he's not subject to the state. He owes nothing to the state.
That's not what Hale v. Henkel says.
Huh?
That's not what Hale v. Henkel says. We've talked about that.
Oh, most definitely does. He owes nothing to the state.
It doesn't. We've talked about this multiple times. You're taking it out of context.
Not at all. I think the last time you said that it was in the dissenting opinion, I went back and I was pretty certain. No, it's not. It's not it's in the majority opinion. It was clearly there, and it's clearly laid out, and it means what it's saying, because the very next sentence certifies that when it says, and he owes no duty to the public so long as he does not trespass upon their rights.
That's not what it says.
Let me pull it up again. Well, I'll read it to you. It's right in the book.
Okay. Well, I don't have to pull it up because I just made a video explaining that very misunderstanding. Look, what it actually says is that there's no such duty to the public. It's talking about responding to subpoenas. It's not talking about you don't have to pay taxes or obey any of the laws of the state. Okay, so Colin and I have been going back and forth about his interpretation of Hale v. Henkel for a while. He still insists that his interpretation of Hale v. Henkel is correct, and that the holdings of Hale v. Henkel support his view that you as an individual cannot be held subject to the laws of the United States or the state that you live in. Now, I already made a video explaining why the text of the decision does not support that interpretation, basically explaining that what Hale v. Henkel is talking about is whether or not corporations have to respond to subpoenas. You can't extend that to somehow mean that you as an individual don't have to obey any of the laws of the United States or the state or one of the states that you live in. Now, Colin was not convinced by that explanation, so I'm going to try two more attempts at explaining to him why his interpretation of Hale v. Henkel is wrong. I was able to find a 1985 decision from Idaho, Gordon v. State, in which somebody tried Colin's Hale argument in court and failed, and it contains a very good explanation of why the Hale argument is wrong. Now, this is a guy that didn't want to get a driver's license to drive his car, and he didn't want to get insurance on his car. Quote, he argued that Hale supported that right. Quote, he principally relies upon quotations from Hale v. Henkel and Thompson v. Smith to support his position. Quote, the Supreme Court held in Hale that a corporation does not enjoy the same rights granted to an individual by the Fifth Amendment to the United States Constitution, specifically because a corporation is a creature of the statute and it is vested with special privileges and franchises. It may not refuse to divulge information based on the constitutional right to remain silent, rather than make incriminating statements in a criminal proceeding. In some circumstances, an individual may enjoy greater protections under the Constitution than does a corporation, but Hale in no way grants to individuals the absolute freedom from state regulation that Gordon insists upon. I was also able to find a decision from 1988 from Illinois, State v. Tangwall, and there another guy tried Colin's Hale arguments. Quote, while defendant cites many cases, he suggests support his argument that Illinois courts have no power over him. Closer scrutiny reveals that he leaves out words from quotations, quotes phrases from cases out of context, and misinterprets the actual holdings of these cases. Defendant quotes Hale v. Henkel, 1906, as stating, quote, the individual owes nothing to the state, for he receives nothing therefrom. Not only does this misquote Hale, but the quote is taken out of context. The actual quote in context is as follows. Quote, he owes no duty to the state or his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom beyond the protection of his life and property. Hale. All right, so what does that prove? One, these are simple explanations of why the Hale argument is wrong. And secondly, it shows that the Hale argument is not accepted in court. So, assuming that Hale really did say what Colin claims it says, the fact that that argument is not accepted in court means it's useless. It's a waste of time to go in there and argue it. And I also want to bring up another reason why the Hale argument fails, and it is that it ignores every other court decision that has ever been made in the 240-year history of this country. I want to bring up State v. Gibson, which is a case that I like because it directly addresses things that we're talking about here. In it, Gibson argued that in order for the laws to apply to him, he must agree that to be subject to the laws, and the court disagreed with that. Quote, "The rights of liberty are not entirely free. Individuals must sacrifice part of their liberty in order to empower government to regulate through passage and enforcement of laws necessary for the general public welfare." John Locke, the English philosopher who wrote of government and freedom, said, "Where there is no law, there is no freedom," quoted in Blackstone's commentary. "A law is an ordinance of reason for the common good, made and promulgated by him who has care of the community." It continues. Blackstone also commented on man's liberty. Quote, "Every man, when he enters into society, gives up a part of his natural liberty as a prize of so valuable a boon, and obliges himself to conform to those laws which the community has sought proper to establish. Otherwise, there would be no security to individuals in any of the enjoyments of life. Gibson entered into our society when he began to live in it. He has no right to unilaterally withdraw from society, rejecting his obligations to that body, while at the same time retaining the advantages of that society, advantages for which others have sacrificed part of their liberty." John Marshall, the great Chief Justice of the United States, said, "The best rule for freemen, in the opinion of our ancestors, those who had produced and ratified our Constitution, was that of obedience to laws enacted by a majority of the people's representatives." In other words, what Colin is arguing, that he has a right to live in Maryland while not being subject to the laws of Maryland and the United States, is something that the courts have repeatedly rejected over the last 240 years. That is not the concept with which this country was founded. The philosophical basis of the United States and the philosophical influences on the founding fathers were men like John Locke, who rejected the idea that you could live in a society while not being subject to their laws. You cannot overturn that simply by quoting one line out of Hale v. Henkel out of context.